following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss marital laws in Sri Lanka. What amendments have been made to the legislature governing matrimonial unions in Sri Lanka? And how is the process of dissolution facilitated? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, tonight's topic is not a topic that we have not approached on this show before, and that's on marital laws and marital dissolution specifically. Now, I'm aware if you have been keeping up with the program, you would have seen we've done a previous program, but since then there have been some updates, there's been some things to keep you updated on. So here we are doing yet another program to just touch up on what we left off on last time. Now, to speak about this very complicated topic of marital laws and how exactly you balance these laws in Sri Lanka, specifically when it comes to the different religious practices as well, we have someone that I believe would be best to explain this situation to you, and that is attorney at law Kamran Aziz. Thank you very much, sir, for taking the time to speak to us today.
Thank you, Anuradhi, for welcoming me on your program.
Yes, of course. A little bit of an introduction on Mr. Aziz. He is also a barrister at law and also specializes in divorce. So safe to say we're in good hands when it comes to the navigation of this topic. Well, before we get into the program, here's a little bit of a breakdown on how we're going to approach this topic over the next few minutes. First, we'll be talking about the current context in Sri Lanka, what the climate is for marital laws and marital dissolution laws in Sri Lanka. Next, we'll be talking about the amendments and divorce aspects specifically, and finally we'll be talking about the future of marital laws in Sri Lanka.
I am Yahari and I am a management student. My question is on matrimonial laws. Which legislature governs marriage and divorce?
Alright, well, without any further ado, let's get right into this extremely packed discussion. We have a lot to discuss tonight. Sir, thanks again for taking the time. We have quite a bit to unravel in this aspect, especially with the amendments that happened and what we're seeing in the current climate so far, specifically in the legal sphere. Before we get into any of that, sir, could you please give us a little bit of an overview of how exactly the current context looks like for marital laws in Sri Lanka?
Yes, thank you, Anuradhi. When we talk about divorce, we need to understand the concept of marriage first. A marriage, as you know, is a contract between two parties. It affects their future, the properties involved, and in the event of death, the succession. So most marriages in Sri Lanka are registered, and some of the marriages also come under this category of people who live by habit and repute. So marriages are recognized through registration as well as through people living by habit and repute. Now, when it comes to registration, it's generally under the General Marriages Ordinance, and 90% of the marriages in Sri Lanka are registered under it. In addition, there are you can get married under the Kandyan law as well as the Muslim Marriages and Divorce Act. Now, when we talk about marriages through habit and repute, which comprises a very small percentage of marriages, those are not registered, but those marriages can be considered as being valid through the parties living together for a long period of time, having public acceptance. In the case of Hindu weddings, the thali being exchanged, and the public ceremony also taking place. So those are marriages through habit and repute. But the majority of marriages, like I said earlier, is through registration, and that is in terms of the General Marriages Ordinance. Now, that is the concept of marriage. Now, when we come to divorce, which is the discussion in point, when it comes to divorce, the general law and the Kandyan law dictate that divorces can only be dissolved through by order of court, by a dissolution by order of court, and that is the district court in which either the plaintiff or the defendant, either the husband or the wife, reside. Whereas when it comes to Muslims, it is the Qazi court that is the applicable court to which where you make the application for divorce. Now, divorces in terms of our law, the General Marriages Ordinance, Section 19, states that it can only be granted under three situations. One is adultery, the other is desertion, and the third is incurable impotence. Adultery is very, very difficult to prove because you need to establish the physical aspect of sexual intercourse by the spouse and prove that in court. Then the second is desertion. So desertion is made up of two parts. One is simple desertion, where the other party, your spouse, leaves you or the matrimonial home with the intention of repudiating the relationship. And constructive desertion is where the spouse leaves the matrimonial home due to the expulsive acts of the other spouse. So there must be a reasonable cause to leave the matrimonial home, and if there was a reasonable cause due to the acts of the other spouse, that is coined as constructive desertion. And the third ground for divorce in Sri Lanka is incurable impotence. That's a situation where after you get married, if there was a situation where you become impotent, that's a ground for divorce as well. So those are the three main grounds for divorce in Sri Lanka. Now when you apply, I have to mention that there is no concept of a failure of marriage or an irretrievable breakdown in marriage based on which you can make a case for a dissolution of the marriage. That concept is alien to our jurisdiction. Then I would also like to point out that in cases of void marriage, there are certain marriages which are void. Void meaning that they are not considered as lawful marriages from the inception. For example, in terms of sections 15, 16, and 18 of the General Marriages Ordinance, section 15 says that you cannot get married to a person who is less than 18 years of age. 16 says you can't get married to your descendants. For example, a mother can't get married to a son, and if a son can't get married to a grandmother, those are unlawful from the commencement. Then also you can't get married to if you have a sister or a brother, you can't get married to them, and even half sisters and half brothers are also considered as unlawful marriages. Then also section 18 says that if you are currently married in terms of the general law, you can't get married again until your divorce is finalized. That's when your decree nisi is made absolute. So those are void marriages. Then there's also a concept, Anuradhi, of voidable marriages. Those marriages, you need to establish a certain element for it to be declared as void. For example, duress, fraud, and mistake are grounds for declaring a marriage void. Those have to be proved by evidence. For example, if you meet someone and that person gave you a false name and identity and you were lured into marrying that person, that's a ground to have your marriage declared void. And then if the person also gave you a false age, or if he or she said that she was not married when in fact he or she was in fact married, those are grounds to declare that marriage void on those grounds. So those are if I can put it very simply, the basis of going to court and obtaining a dissolution of marriage in your favor. Now, once you go to court, the next step, now you have a ground to go to court, and you file a divorce action, and then you need to ask yourself what you can obtain from court. Now, when you file a court case, and if the main prayer is that you will ask for a dissolution of marriage in your favor, either on desertion, adultery, or impotence. Then you can also ask for the custody or access of, if children are involved. You can ask for a sum of money. You can ask for a sum of money in the interim, and also a sum of money at the end of the case. It's called permanent alimony or alimony pendenti laite. Permanent alimony is when you ask for a gross sum of money at the end of the case, whereas permanent pendenti laite is during the pendency of the case. You can ask for a monthly maintenance sum. Then you can also ask for a settlement and conveyance of properties. So there are marital properties which are acquired during the pendency of the marriage, which either party may have a right to. Then you can ask for a settlement or conveyance of those properties as well. So in addition to that, you can ask for interim orders regarding the custody, maintenance of the children involved, and other ancillary reliefs. So those are broadly the framework of the relief that you can ask for in a divorce case.
Right. So there is quite a few features and also quite a few, well, not leeways, but avenues on which you can actually travel to in order to obtain a divorce or a dissolution of marriage. So I'd like to just actually ask you a question of curiosity. When it comes to voiding a marriage and having a voidable marriage, where do you, in your opinion, with your experience, where have you seen it become the easiest to actually obtain a divorce? Because we see that, since there are multiple areas on which you can contest and on which you can ask for divorce, where do you see it become the easiest?
If a marriage is void from its commencement, that is, you have contracted a marriage which is not permissible by law. For example, in terms of Section 18, you have already married to someone and you cannot get married again, but notwithstanding that, you commit that act. So that marriage is completely unlawful from the commencement. So therefore, you need to go to the district court and declare that marriage annulled, declare it a nullity from the commencement. So you need that case will have to be filed in the district court. In addition, for avoidable marriages, so for example, someone induced you, so and there was fraud involved, or there was a mistake involved that substantially affected the rights, then you can go and declare that your marriage be declared a nullity and void for these reasons.
Right. So there are specific avenues where it's much easier in comparison to certain already existing means of getting a divorce. I think I would like to focus a little bit on this specific issue that has been, of course, in discussion in public sphere for quite some time, which is the marriage age, the maritable age, and also consent issues. Could you please just give us a little bit of insight on that aspect and how the legislature in Sri Lanka actually approaches that?
Yes. So the age of marriage is 18 in terms of the General Marriages Ordinance. There was a discussion to increase the age of consent when it comes to female Muslims married under the Muslim law, to increase that, but I don't think that succeeded. I think that's still in discussion. But at the moment, the majority of people living in Sri Lanka are governed by the general law, so the age of marriage is 18 years at the moment.
Right. So 18 years for mostly everyone,
yes.
Apart from specific religious aspects. I think that's a good segue for us to get into that aspect as well, because it's not just one law that's operating in the country when it's related to marriage. It's very diverse. Could you please explain to us how marriage translates through these specific differently existing laws in Sri Lanka?
So, for example, under the general law, once you are married to a person and say, for example, the husband passes away. So the husband's property, in terms of if he didn't leave a last will, it's considered as an intestate estate, and half of his estate will devolve on his wife and the other half on his child or children. It's a bit different when it comes to Muslim law and the Tesavalami, the law applicable to Jaffna Tamils. In that, there are certain the inheritance and how it's devolved differs in terms of those personal laws.
Right. So is that the only key difference we see, or are there other variations as well?
In respect of
not just property division, but also the necessities in order to enter marriage.
Yes, of course. The necessity to enter marriage, you need, now for example, in terms of the general law, there was an element where you needed the consent of the parents. In terms of the Muslim law, if a lady marrying needs a wali, a father figure, it's usually the father or father figure, who will attest on her behalf at the time of signing after the nikah ceremony. So in terms of these personal laws, there are slight variations in the procedural aspect.
Right. So procedurally we see certain differences, but essentially it's almost quite similar when it comes to the essence of...
The essence of all these personal laws in respect of marriage is that both parties understand that it's a contract where their rights are intertwined for the foreseeable future.
Right.
And that is the concept of a relationship of marriage, because it's based on contract.
Right. So I think that's an important aspect for me to pick on. So now we just spoke about union, we just spoke about marriage, but how do divorce laws actually fare across the different existing legislature that we have? Is it the same that we saw for marriage, or is it different?
It's a bit different, Anuradi. For example, most of the countries in the world still adopt a fault-based divorce system. A fault-based divorce system is that you need to prove that your spouse had committed a matrimonial wrong. Now, in terms of the general law, which I just mentioned earlier, the three faults are desertion, adultery, and impotence. And in most countries, this fault-based divorce system is applicable. But I can see a positive change from the recent past, where a lot of countries, including Singapore, India, and even South Africa, are moving away from this fault-based divorce system and are basing their divorce procedure on the concept of irretrievable breakdown of marriage. When there's an irrevocable breakdown of marriage, without providing the fault of the party of your spouse, you can obtain a dissolution of marriage, which makes it easier. Because in our system, unfortunately, by trying to prove a breakdown of marriage, a fault in the other party, will require the calling of evidence, basically washing dirty laundry in public, because unless you have a closed court, all these divorce cases are taken up in open court, and while other litigants are watching, all this laundry is washed in public to prove their fault by document, by evidence, and it can become sometimes quite dirty, unfortunately. As lawyers, we have experienced this, and I think that if we can also adopt a system where parties can, by consent, on the basis of irretrievable breakdown of their marriage, seek a divorce, that will also perhaps avoid this.
Well, we do have to get into the aspects of the global standards and also how exactly we fare and how our legislature fares in comparison to these global standards, specifically when you mentioned the breakdown of marriage and how it's not having to air dirty laundry. But before we get into any of those discussions, let's go in for a short commercial break. You're watching Law, Land and Liberty. We'll be right back.
Hello, my name is Asun Vijayaratna and I am a business student. My question today is on the current climate. What are some key changes proposed to existing legislature?
Welcome back to Law, Land and Liberty. We are in conversation with Attorney at Law Kamran Aziz, and we were just speaking about divorce laws and marital laws and how it is in the current context and the basics of how it differs across different religious customs. Now, I believe, sir, since we have a good preamble into what exactly it looks like in the current moment, it's important for us to pick up on what the previous episode was not able to cover, which is on the amendments aspect and also the developments when it comes to marital law. Specifically, could you please give our viewers some insights relating to exactly what developments have occurred in the legal sphere in relating to marital laws?
Yes, thank you, Anurag. On the developments that are, I think, going to happen in the near future are two very important bills, which I believe are going to be presented to Parliament very soon. In fact, in 2007, approximately 16 years ago or 17 years ago, there was an attempt by the Law Commission of Sri Lanka to propose to take away this fault-based divorce concept. And that has been, I think, even sought to be done even prior to that. But unfortunately, for unknown reasons, it has not happened. And I think there's a very firm, definite attempt now to put forward this bill, where it will take away the concept of fault-based divorce and also allow parties to file action or file a divorce case based on a breakdown of the marriage, on the basis that the marriage has collapsed. And that will make it easier for parties to file action and obtain a divorce in a favor. Because this is very important, because the more a divorce case is prolonged, it will be good for lawyers like me, but for litigants, the more divorce case takes. I've handled divorce case, unfortunately, which have taken a very long time. And it is not only the litigants who suffer, it is children, because in most circumstances, the children are used as pawns between the mother and the father. It's a very unfortunate situation. And they have to endure this long legal battle until the divorce is confirmed. In addition to that, even the parties, they have to suffer. They have to appear in court every 2-3 months. And if it's not settled between the parties, if there's no reconciliation regarding a settlement, it'll probably go on for 2-3 years, and during this time they have to attend courts, and their divorce is not finalized, and they cannot move on with their life. This also affects now say hypothetically, a divorce case takes about 4 or 5 years, and since the filing of the divorce case, either party, it can be the husband or the wife, we can't expect them to be single for the next 4 or 5 years. It's not natural. And so when they meet someone, if that third party's expectations must be also taken into consideration, because either he or she would like this divorce case to be concluded expeditiously. So we need to focus on that. We need to develop laws, and I think that's a very good attempt by the Parliament to seek and the Justice Minister to produce this bill in Parliament and get it passed, which will help get this ball rolling in the correct direction.
Right. So now specifically in relation to the bills, apart from the fact that it's trying to move away from a fault-based system for the dissolution of marriage, do we see any other key aspects that have been addressed when it comes to marital law?
Yes, there's one other very important aspect. Anuradhi, in regard to the recognition and enforcement of foreign divorce judgments. This also is an attempt by the Parliament to produce a bill and get the ball rolling in that avenue. I think there was a judgment in fact of the Court of Appeal very recently in 2021, a case filed in 2021 rather, where it held that if parties who have contracted a marriage in Sri Lanka, but who are both living abroad and have been living abroad for a considerable period of time, and who file the case in a proper court, a competent court in another jurisdiction, and if they are also both properly represented, they can obtain a divorce in that country, which will be recognized here. So I think that's a good development in the law, because it doesn't require both parties or either of them coming to Sri Lanka just for the sake of obtaining a dissolution of their marriage. This is also it's important in the present context, but since unfortunately quite a few people are thinking of migrating abroad these days. So this might be applicable to them. If they're thinking about this, then this might also be helpful to them.
Right. So we see that these kinds of bills, even though they're still in the works, if they are to be implemented, it will greatly expedite the process of divorce, and therefore making it easier on all parties involved.
Absolutely, absolutely. Divorce is something that must be thought of as only a last resort. I believe that, divorce lawyer, but I strongly believe that any relationship can be mended, and only divorce action should only be filed when both parties or one of them think that there is no further point in this relationship and it has come to a finality and end. So it is only at that time that you think about a divorce, and at that time these new procedures will, which seeks to expedite the institution and the conclusion of the divorce case will be helpful.
Right. And so specifically speaking about the fact that divorces, well, we do see that it's not extremely common, but we see it increasing in number. And I'd like to ask you, sir, you just mentioned that divorce can be a last resort. Is there anything or any practices that have been recommended by the legal institutions or the courts institutions in Sri Lanka before heading to divorce?
Yes. Just on that note, Sri Lanka has one of the lowest divorce rates in the world. Some statistics put it at 0.15 for every 1,000 marriages. That's 0.015 as a percentage. That's very low. And there are several reasons for that. Some say it's attributable to gender inequality, then the stigma regarding the divorce, when there are children involved, when there are financial considerations. Yes. So prior to even contemplating proceeding with the divorce case, there are avenues that are available. For example, counselling, mediation, and even after a case is filed, the judge conducting the case usually refers the parties to a family counsellor to see whether they can mend their differences, reconcile, and live again. And it's only once they cannot do that they proceed to the next stage. Even in terms of the Muslim law, the parties are referred for mediation and given a cooling off period, and if they can't do that, then the divorce is confirmed. So I think that is also important, because like I said, Anuradhi, divorce should always be the final measure in a relationship between a husband and a wife.
Right, and it's important that viewers understand that it is a final measure and not just the first resort that you turn to when things go south in a union. I think it's important for us to speak about what you just mentioned, the fact that we have a very low divorce rate and not necessarily due to optimistic reasons. Could you explain to us how accessible do you believe the legislative system or even our advisory system is when it comes to divorce? And when it comes to obtaining a divorce or marital counselling, how accessible do you believe it is?
I think we need to work a little bit better on this topic. I think accessibility with regard to information about these rights are limited, especially when you go out of the Western province. I think, and we need to focus more on that, and because I think generally it is the female population who suffer due to this, because it is them who are usually at the receiving end instances concerning abuse in a marriage. So in those situations, I know they apart from the fact that they're confined and they always think twice about going, they also that the information that's available to them is also limited, to understand the issues regarding divorce and how to proceed with a divorce case.
Right. And so what are your thoughts on the stigmas relating to divorce? We just touched on it very briefly previously as well. We do have an unfortunate taboo relating to this subject. What are your thoughts on it?
I think that taboo is slowly is reducing, and that's a good sign. I think there are women who are now more independent compared to several decades ago. Women are employed now; they know exactly what they want. And there's a parity in marriage, which was not there in existence some time ago. So unfortunately, women had to endure unhappy marriages for a long time, and so did men actually. But when the marriage relationship is not equal, when there are issues between the parties, it was usually the women who suffered at the hands of the men, and they didn't bring out this because of family considerations, financial considerations, when there were children involved. So all these things would make them think twice about taking the next step. But now women are more educated, they're more independent. That's a good sign. And when the marriage doesn't seem to work as the last option, then they will proceed to divorce after considering all other avenues.
Right, we see slow but steady progress.
Absolutely.
in a good direction. So we just touched on, you just mentioned the aspects of custody and also the financial disparity that could occur due to certain power imbalances and separations in the union that's already existing. Could you explain to us how exactly the custody aspect is approached, because that is, after all, one of the most traumatic aspects of divorce?
Yes, absolutely. Custody in our law, the preferential right to custody during the pendency of a marriage lies with the father. That's the law. Except in the case where the child is a very young child and would require the mother's assistance. So from say birth to about 2, 3, 4 years, the preferential right of custody, as long as they're both together in a marriage relationship, is with the mother. But after that, it's with the father. After 14 years for a boy and after 16 years for a girl, their views are also taken into account when considering custody. But as a general rule, the custody is only determined based on one factor, that is what's in the best interest of the child. What is in the best interest of the child, the development and the welfare of the child. And that will be determined by the relevant district court, being the upper guardian. We call it the upper guardian because the district court is considered as the only person who can look after in an independent manner the welfare and the interest of the child in a divorce case.
Right. And moving on to the financial aspects as well, sir, we just briefly touched on alimony, but how exactly can the court aim to balance any sort of serious disparities that could occur due to a divorce?
That's a very good question, Anuradhi. That's a very good question. Unfortunately, our law does not have specific considerations or doesn't specifically state as to how to compute alimony. Our Civil Procedure Code, section 615(1) says, if it deems fit, if the court deems fit, it can direct the payment of money, conveyance of property, and so on and so forth. So alimony comes under that as well, and the court is also empowered to effect a conveyance of property or settlement of property, matrimonial property, to effect the balance. Now, what is most important is the spouse who is seeking alimony or is seeking settlement of property must show that without this, that spouse cannot sustain his or her lifestyle for the foreseeable future. So that is what's paramount, and that is what the district court will take into consideration when considering and determining these factors.
And sir, on that topic in itself, do you believe, with your experience having been in this field for quite some time, do you believe that the process of obtaining fair alimony, in your opinion, has been more of an arduous process in the eyes of Sri Lankan law, or have you seen preferential treatment?
That's a very good question and a very difficult question, Anuradhi. It's like this. You can see a big disparity in the awarding of alimony depending on the income of the spouse or the spouses involved, and the requirements and the properties involved. I would, if parties settle in a case, and obviously that settlement would be acceptable to both parties. But if the case goes on for a few years and the party seeking alimony perhaps gets much less than he or she expected, considering the status. But there are avenues to challenge that. You can go up to the next higher court and to the Supreme Court and all that. Those are there. But it all depends on the evidence in the case, the financial capacity, the requirements. So those are all things that have to be taken into account by the district judge who's determining the case, and by the appeal judges, if at all, in considering whether the alimony granted is fair and reasonable, having regard to these considerations.
Right. I think, unfortunately, our time has come to pass in this segment, so we do have quite a bit more to discuss on, specifically the future of marital laws in Sri Lanka, especially with the bills coming in, and also how we stand on a global context. We do have a bit more to discuss, but before we do any of that, let's go in for a short commercial break. You're watching Law, Land and Liberty. Stay tuned.
Hello, my name is Silvi Mansa and I am an IT student. My question is on the future of marriage and divorce in Sri Lanka. What are the biggest changes we should expect to see in future amendments?
Welcome back to Law, Land and Liberty. We are in our final segment in discussion with attorney at law Kamran Aziz. Sir, I think we just went through two very informative segments and our viewers have probably picked up quite a bit relating to what exactly has changed over the past few years relating to marital laws in Sri Lanka. I think before we say goodbye to the local context and we tap into a little bit of the global aspects as well, I'd like to ask you about any key landmark decisions and court rulings that we have seen in relation in this field of marital law. Could you please give us some insight on that?
Yes, Anuradhi. One judgment which I would wish to emphasize on was this landmark judgment of the Supreme Court pronounced on the 7th of June 2018, about almost 6 years ago. Now, this was a case where the wife filed action in the District Court of Mount Lavinia in 2001, about 23 years ago. She filed action on the basis of abuse. The husband had allegedly assaulted her and even poured kerosene over her. The district judge, the district judge, determined that she had not proved this aspect. Now it went up to the Supreme Court, and there's also the wife also came back after alleging that there was desertion on her on the part. She also came back and lived with the husband again. Now the Supreme Court held, it's a very important judgment, on that since the wife had failed to prove one of the three elements of divorce, the marriage could not be dissolved. Now, the Supreme Court also understood and highlighted the fact that it is constrained because of the law, and this needs to be looked at by Parliament, because now what is the effect of this judgment is that you can be separated and you could have suffered abuse, but you have to live, you are recognized as husband and wife in the eyes of the law. So this, the Supreme Court had rightly pointed out that this avenue needs to be looked at by Parliament. I think this is one of the reasons that the Parliament is now proposing this bill. The second judgment which I wish to point out is the one we discussed earlier, where the acceptance of foreign judgments are involved. So if these, there are three requirements. The case number is CA Writ Application 266 of 2021, and there are certain conditions to be fulfilled, and if those conditions are in fact fulfilled, foreign divorce judgment can be recognized and enforced in Sri Lanka. And these are two new judgments seeking, and I think these are good, the positive judgments which to develop the law of divorce.
Right, so we've seen a lot of movement towards progress in Sri Lankan legislature as well. It's not just that we have archaic laws, we actually do have some form of progress happening in the courts. We see development. It's slow, but it's hopeful, so hopefully our viewers can also hold on to some hope about the reformation aspect as well. Actually, before we get into the reformation aspects, I'd like to ask you a little bit, we touched on it very briefly previously, relating to global standards. Do you believe that with the current pace that Sri Lanka's legislature is working at to actually resolve any issues in marital laws, will we be able to stand on par with other developed nations and their laws on marital union?
I think the work that has been done now will put us on the correct path. This should have been done a long time ago. That could have been avoided, but now, at least now, still for all, we are going on the right path. And I think if we carry on in this trajectory, I think we will be able to achieve what we desire and what we want. Now, for example, there are certain other things that could be also incorporated. Video screening of children, the evidence of children, without them coming into court. If the evidence can be given in a private room with a camera, that will assist in these divorce cases. And also, even if we have to proceed with this fault-based system, you can have measures to expedite the conclusion of these cases without them carrying on for years on end. That will also be a big deal. So if there are certain, I'm not saying that we are on the right trajectory completely, but there are certain avenues which need a bit of fine-tuning in addition to this path that we are taking.
Right. And sir, a question of curiosity, what do you believe the future of marital laws and divorce laws look like in the Sri Lankan context? In what way are you asking? Will we see a very rapid and exponential development when it comes to marital and divorce laws, or will we happen to see the same status?
No, I think there are laws that are coming into place, not only in respect of divorce law. There are other laws which have also been amended to bring it in line with international acceptable norms and standards, inclusive of divorce law. So I think the government is doing is on the right track. Is doing what it can to amend these certain archaic laws to bring it in line with acceptable practices and international standards.
Right. Sir, again, I'd like to ask you, well, this is a bit of advice and a little bit of information for our viewers specifically watching. When it comes to the areas of divorce, we see a lot of taboo, we see a lot of stigma, a lot of misinformation as well. Is there anything specific that one should look out for when it comes to seeking divorce or even having to face divorce in any aspect? Is there anything specific that we should be looking out for?
Yes, Anuradhi. First and foremost, like I told, we discussed earlier, divorce should always be the final decision that you make. And when you come to that decision, you need to look out, you need to ensure that without prolonging it, if you can work out with your spouse a way of amicably settling the divorce case in court, that will be the best outcome for everyone. So if you can have a agreement with regard to how the divorce is, in whose favor the divorce is going to be, if there are children involved, in whose custody, they're going to be. You need to agree on the legal and physical custody of the child or the children, then access, then how to communicate with them when they are not with you. Also, if you want to take the children abroad, how will you do that? Then the maintenance of the child, their welfare, their health, their education. Then also, you need to also have an agreement as to what happens if they go abroad and all those. So that if all those issues can be ironed out and sorted out at the end, then a divorce case can be resolved very, very expeditiously, I would say, even within 3 months. So that will greatly assist without coming to court and fighting for years on end. If you can, it'll have to be a bit of a give and take between the parties. You can't expect everything. You can't expect your own pound of flesh. But if there's a give and take between the parties and they act in the best interest of the child or children, that would definitely assist them in the long run.
Right, and before unfortunately we're running out of time, but I'd like to ask you, building on that question, sir, when it comes to amicable separation, how does that translate when we're already working in a fault-based system for divorce?
Yes, good. That's a good question. So, so you come to court, you inform the judge that these are the settlement terms regarding custody, maintenance, and property considerations. But you still, for all, have the one party has to get into the witness stand and in a very short testimony say as to why this marriage ended and put the fault on the other party. But we don't go into specifics. We keep it very simple. Although there's a fault attributed to the other party, we limit that so that in order to not cause any harm to the settlement reached between the parties. So just to facilitate that and the law, we attribute some fault to the other party.
Right. So does that mean the court does essentially actually facilitate the expediting of such a process?
Yes, the courts always ask if there's a settlement in a divorce case, and if there's a settlement, they expedite the hearing of it, and which helps litigants to conclude it expeditiously. Yes, that our court system has always encouraged, and that's a good sign.
Right, that is a good sign. I think I'd like to ask you once again, sir, now when it comes to the reforms aspect, where do you think is the most dire in terms of the marital and divorce laws? What needs addressing first and foremost?
I think this fault-based system needs to be amended or taken out with completely, or amended to bring it in line with international standards. I think by trying to prove a fault in a relationship is only going to cause, especially if you have children, it will cause much prejudice to them and the parties. So if we can also have a system which you can make an application on the breakdown of the marriage, that will facilitate our entire system and our laws greatly. In addition to that, if you can also have amendments to alimony, if there are laws brought in place as to how the calculation of alimony, that will also be important, because at the moment there is no such law, which I said to you earlier, and because of there not being any such law at the moment, there might be certain inconsistencies between persons and between in situations when you consider we have so many district courts all across the country.
Right, sir, and a question of curiosity, sir, do you believe that if we are able to bring in these reforms and actually stabilize our laws a little bit, do you believe that the problem of marital unions and divorce will we see a statistical change? Will we actually see it reflecting in our population?
Perhaps divorce rates will increase, but at the same time, women in suffering abuse in marital relationships will decrease. There are other social factors which might decrease as well at the same time. So people who live in unhappy marriages will decrease. Children who are suffering because their parents are in unhappy marriage will also decrease. So those are factors which also can be taken into consideration when looking at that aspect only.
Right, and another question of curiosity, sir, when it comes to the aspect of having international travel or international departure or even residing in another country, we mentioned that a bill is being brought up to address specifically that. Do we see a difference in the approach by courts towards such a union? No, there is no such recognition by our courts for such a union at this moment. Do we need it?
We don't need it. We don't need it.
because of the fact that despite there being international aspects involved, the union still happens.
The union still happens in Sri Lanka. It's recognized as a marriage contracted in Sri Lanka, and for all purposes, you can still obtain that divorce in Sri Lanka. So it's only applicable when those parties, both of them, go abroad and they wish to divorce abroad, and they're both represented abroad, and they've both been staying for a considerable period abroad where that amendment applies.
So it doesn't work when one foot is in Sri Lanka and the other is in another country. Exactly, that's a very important point to actually keep in mind because
this judgment specifically says that both parties must have been living there for a considerable period of time.
Right. So there has to be an establishment of that fact.
Absolutely.
All right. So, well, before we go in for any conclusions, would you like to address our viewers on exactly, well, of course, you're not a marriage counselor, sir, but you have had quite some experience when it comes to divorce. What's your opinion? Do you have any information or advice to give to unions, to actually individuals that are in marriages in order to actually not have to go to divorce?
Like I said earlier, it will go against my profession to say this, but like I said, divorce should always be a last option. Like in any relationship, a business relationship, a friendship, a relationship with your parents, anything, and even a marriage relationship, you should always try to resolve any conflicts and try to move forward. It is only when you can't, and then you come to that final hurdle and you can't, go any more as a last option that you must consider divorce, and then even then try to go for counselling and see whether you can resolve. But if you can't, then go to court and try to amicably resolve it in the first instance. It's only when you can't amicably resolve it that you might have to face proving your case in court.
Right. So rest assured, as long as there is a plan, if God forbid there needs to be a separation, there will be legal provisions that are available to individuals. It's not that the law is inadequate to address such issues.
Not at all, because our law safeguards both the husband and the wife and the children. So that you don't need to worry or be concerned, because the law will always protect the party who has suffered something through the marriage.
Right. I think at the end of the day, that's the most important thing to know that the legislature and the law has your back, and it's not just something that exists merely for the advantage of a specific gender or a specific demographic. It applies equally to all. Well, unfortunately, we have come to time in this discussion. We did get to discuss quite a few varying topics. Thank you very much, sir, for taking the time to speak to us on this topic. Thanks again, sir.
Thank you very much.
All right. Well, with the significance that marriage holds in Sri Lankan culture, it's important that we remember to distinguish laws from customs to better be sensitive to subjects of marriage and divorce. We leave you tonight with the words of actor Helen Mirren. Great marriages are partnerships. It can't be a great marriage without being a partnership. That's all we have for you on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/otherderana English. Thank you very much for watching. Have a good night.